We are live, sir.
A very good afternoon to our honorable chief guest, my senior colleagues, parents, and dear students. I would like to take this opportunity to welcome the class of 2021 to the JGU family. Although these are the difficult times and we are welcoming you all virtually, it goes without saying that we are in this together and we will find our way through the pandemic while continuing our pursuit of knowledge. Once again, heartiest congratulations to each and every one of you, and I wish you all the very best for the exciting law school journey ahead that you are embarking upon. My name is Shambhavi Shivani. I'm a lecturer and an assistant dean, career services at Jindal Global Law School, and I'm honored to be presenting the commencement lecture event on the theme, The Art of Advocacy and Contemporary Lawyering for the 5-year programs, that is BA LLB Honors, BBA LLB Honors, and BCom LLB Honors. It is with great pleasure I invite our first speaker for this event, Professor Dr. S.G. Srijit, Professor of Law and Executive Dean, Jindal Global Law School. Professor, may I request you to deliver the welcome address?
Thank you. Thank you very much. Good morning, everyone, and welcome to the commencement lecture of the academic year 2021-2022. The theme of the commencement lecture is Art of Advocacy and Contemporary Lawyering, which will be delivered by Dr. Abhishek Manu Singhvi, Member of Parliament and Senior Advocate, Supreme Court of India. Lawyering is a natural transition from law school. Having obtained the knowledge of law and the ability to apply that knowledge, the proverbial law student makes a transition to lawyering. Lawyering is indeed a skill much needed to succeed in legal profession. However, when it becomes an art, lawyering transcends from being a professional activity to an act of joy. As an act, lawyering gets an aesthetics, a theme, and a beauty. Practice of law as an art makes justice a piece of craft, a marvel. But forget not, we live in troubled times where uncertainty is the order. In the maelstrom of real politic, as values tend to evanish, law helps us find divinity in the dry marrows of society. Law is hence the hope and perhaps the sole consolation. Today we have the opportunity to hear more on the constructive potential of law and the art of its practice in our times from one of the finest artists of justice. I take this opportunity to welcome Dr. Abhishek Manu Singhvi, our distinguished commencement speaker. I also extend a warm welcome to Professor C. Rajkumar, my Dean and the founding Vice Chancellor, OP Jindal Global University. Professor Sridhar Patnaik, Registrar, OP Jindal Global University. Professor Anand Prakash Mishra, Director, Law Admissions, OP Jindal Global University. Ms. Shambhavi Shivani, Lecturer, OP Jindal Global University, and the Master of the Ceremony. My dearest students, their parents and well-wishers, my colleagues, and everyone else watching us through YouTube and Facebook channels. I welcome you all to the commencement lecture and to the new academic year. And to the students in particular, welcome to the world of law, a world of immense and numerous possibilities. Thank you.
Thank you, Professor, for those golden words. OP Jindal Global University, as we see today, is because of its ethos and the remarkable vision and mission of Professor Dr. C. Rajkumar. The journey, ever since 2009, has in itself been a motivational and encouraging one. It is my privilege to welcome Professor Dr. C. Rajkumar, founding Vice Chancellor of OP Jindal Global University and the Dean, Jindal Global Law School. Professor, may I request you to share the journey of OP Jindal Global University, including the Jindal Global Law School, and introduce our esteemed chief guest for today's event. Over to you, Professor.
Thank you very much, Shambhavi. What an extraordinary day that we have with us. First of all, I want to extend a warm welcome to our honorable chief guest of the commencement lecture, Dr. Abhishek Manu Singhvi. Before I speak more about him, I want to take this opportunity to congratulate the students who have not only braved the pandemic. The last year has been extremely challenging for all of you. You have not only stayed through your schooling, you went through the uncertainty surrounding the 12th standard examinations, and of course could not even take a proper break, didn't have vacations in between, hardly met your friends or rejoiced about your achievements, and here you are entering into the portals of an academic institution to begin your academic journey. I can only say that this is your own resilience, determination, and dedication that has brought you to where you are today. I want to take this opportunity to welcome you to OP Jindal Global University and Jindal Global Law School. I would like to commend and congratulate you for showing that determination and perseverance to overcome these tough times and commence your higher studies with Jindal Global Law School. It is truly remarkable that you rose up to the occasion and ensured that the global pandemic did not lead to the loss of your academic pursuits. At JGU, we have always been conscious that you, our students, are the raison d'etre for the university, and hence all our academic and administrative capacities are oriented towards providing the best environment for you to have a holistic education. I am confident that the university, including the faculty, the staff, the peers, and all other members of the JGU community, will inspire and motivate you to work hard and engage with important issues that help you to make a difference in the world. Of course, I look forward to seeing you sooner than later, as we miss our students profoundly being with us on our campus. There is no campus life without the most special people, that is our wonderful students. We look forward to bringing you back into the campus as soon as possible, keeping in mind the safety, security, and well-being of the students, faculty, and staff members, and also while ensuring full compliance with government and regulatory guidelines during this pandemic. I also want to particularly mention that the 5-year students who are part of the BA Honors LLB, the BBA Honors LLB, and the BCom Honors LLB program, in whose welcoming gesture that we have organized this commencement lecture, you are entering into the portals of an academic institution that has achieved excellence in the last 12 years. OP Jindal Global University has been consistently ranked as India's #1 private university, and our law school, as you know, has been ranked India's #1 law school as well. Besides many accolades that we have received as an institution, I want to mention that the most important aspect of OP Jindal Global University and its first school, the Jindal Global Law School, is the extraordinary faculty, the outstanding qualifications and experience that they bring to the institution. So these individuals, I believe, are going to shape the future of each one of you in terms of providing inspiration and creating an intellectually vibrant ecosystem within the campus. I want to take this opportunity to wish you the very best in your academic endeavor. Let me now quickly move into the special nature of this occasion itself. Today, we have assembled here to mark the beginning of the academic year. As you know, the formal classes for the first-year students will begin on Monday, 16th August 2021, which is a few weeks from now. It is our tradition that we begin the academic year with a commencement lecture by a distinguished individual who has contributed significantly to the evolution of law and indeed the development of the profession itself. We are very fortunate that we have with us as the chief guest for today's function as the commencement lecture, Dr. Abhishek Manu Singhvi. Dr. Abhishek Manu Singhvi is an eminent jurist, a politician, a very visible media personality, a well-known columnist, author, thinker, and commentator. I must add that he is also one of those individuals who deeply inspired me for many years and has been a very dear friend of OP Jindal Global University and Jindal Global Law School. He is a member of parliament pursuing his third term, the senior-most national spokesperson of the Congress Party, and the youngest designated senior advocate at the Supreme Court of India at the age of 34. I must say that the age of 34 is important for me. I became Vice Chancellor at the age of 34 as well. He was the youngest additional Solicitor General of India at the young age of 37 and the former elected Vice President of the Supreme Court Bar Association. Additionally, Dr. Singhvi was also the former Vice Chairman of Congress's Media Department and former Chairman of the All India Congress Committee, Human Rights Department, and the Parliamentary Committee on Law and Justice, Personnel and Grievances. He has also been a member of the Indian Supreme Court, where he created and administered bilateral legal forums, including the Indo-British, Indo-US, Indo-Canadian, and Indo-Israel legal forums. After obtaining his Bachelor of Arts Economics degree from the St. Stephen's College at the University of Delhi, Dr. Singhvi went on to complete his MA and PhD from the Trinity College, University of Cambridge, and Harvard University, respectively. He has taught at St. John's College, University of Cambridge, and had joined a brief summer program at Harvard University as well. He has delivered lectures to students, faculty groups, and general audiences at Stanford, Harvard, Yale, Boston, MIT, and George Washington universities, as well as non-governmental organizations, think tanks, research institutions, and addressed several international conferences, including those at Paris and Pakistan. He was a visiting Trumbull lecturer at Yale University, USA in 2011, and is currently an honorary professor at Jindal Global Law School, OP Jindal Global University, where he had taken time out to teach full-fledged courses for our students. I could not think of a better person who could join us today to celebrate and welcome the new students who have joined the 5-year law programs at Jindal Global Law School, OP Jindal Global University. Of course, he will formally begin this lecture after a short introduction about the class itself by our Associate Dean and Director of Law School Admissions, Professor Anand Prakash Mishra. Now I invite Professor Anand Prakash Mishra to introduce the class of BA LLB Honours, the BBA LLB Honours, and the BCom LLB Honours class of 2021. Thank you very much.
Thank you, Vice Chancellor Professor Rajkumar. This is an honor for me and a proud privilege to welcome our chief guest, Honorable Member of Parliament and Senior Advocate, Supreme Court of India, Mr. Abhishek Singhvi, and to welcome the class of 2021 to this very special commencement lecture. I'm delighted to inform our chief guest and the audience that this class, which Dr. Singhvi is addressing, is a class of 780 students, and their parents are also attending this special commencement lecture. These 780 students come from 28 states and 6 union territories in the country, almost every part of India. There are students coming from many Middle East countries and some students who have studied their class 12 from schools in Singapore, in UAE, in other parts of the world as well. The most important feature of this class is, for the first time in the history of our law school, 60% of the class is women candidates. 429 girls have joined us in our 5-year integrated BA LLB, BB LLB, and BCom LLB honors program, and 361 boys have joined us. For the first time in the history, 60% of the class are girls. And this was very much visible in the applications itself, where we received 7,602 applications this year for admission to the law school, and 60% of the applicants were girls from all over the country. The other important fact I would like to share with our Honorable Chief Guest and Honorable Vice Chancellor, who is also our founding Dean of the Law School, that this class, the class of 300 students in the BA LLB Honors Program, 300 students in the BBA LLB Honors Program, and 180 students in the BCom LLB Honors Program, comes from some 300 top schools of this country. Almost every top school, in my knowledge, from around the country, in every city, from Delhi to Andaman, have joined our class. And I'm extremely proud of this diversity, extremely proud of this class which has joined us. Over 200 students are those who have secured an entrance exam score more than 90 percentile in their entrance exam. And I must say it's a great moment for all of us to welcome those students to this very special session, as well as I think there could be no better role model than our chief guest himself to hear from him as the first lecture of their class of 5-year law program this year. So with these words, I'm extremely delighted and happy to welcome our students to this session. Thank you so much.
All right.
Thank you, Professor Mishra, for introducing the class of 2021. Dear students and viewers, we have now arrived at the most awaited moment of the event. It is my honor and privilege to welcome the distinguished chief guest once again, Dr. Abhishek Manu Singhvi, Member of Parliament and Senior Advocate, Supreme Court of India, to deliver the commencement lecture.
Vice Chancellor Raj Kumar, distinguished members of a distinguished faculty, above all, the students, and of course, all their associates, proud parents. It's about 12:17 now. I was budgeted for about an hour. I'll try to take a little less. And we, of course, will have question answers even if we exceed the time of 1:30. And I'll try not to lead you into a situation where you start saying that you can speak for as long as you like. We'll leave after half an hour. Friends, this is truly and certainly the commencement of a vital phase of your career. To those of you who have a pretty good idea of what you would like to do with your life, all I can say is congratulations. For many of you who maybe don't have it all figured out, and I was part of that majority during my times, it's okay. It's the same chair which I sat in which a lot of your faculty sat in. Enjoy the pressure, enjoy the search without succumbing to the pressure of the result. And I think as Will Ferrell, a well-known author, said, he said, trust your gut. Keep throwing darts at the dartboard. Don't listen to the critics and you will figure it out. The actress Helen Mirren put it very well also. She said, and this is especially appropriate, I think, to starting or commencement students, the trick is to listen to your instinct. Grab the opportunity when it presents itself and then give it all once you have grabbed it. Earlier in the morning, with Raj Kumar's usual healthy trust deficit query, he telephoned me, I'm sure to check up whether I am going to be around or not. And in that process, he told me that when I asked him exactly the profile of the listeners, he said they're all new entrants. And then he added, who are innocent. This was the most innocent statement from an experienced vice chancellor, which I've ever heard. So I told him that not only is he wrong, but assuming that they are innocent, they will soon lose their innocence because they're all lawyers, as you tell me, to whom I'm speaking, or at least say to be lawyers. I am not very sure that what I am delivering is technically a commencement speech, because the commencement speech also includes addresses of a similar nature to graduating classes. But this is also, of course, a specific subcategory of the commencement class, namely lawyers or to be lawyers. Let me at the outset, before I come to the more particularized theme, tell you the obvious. And stating the obvious is sometimes important to underline and express our gratitude for, as they say, your chilies or your beans. You are lucky because you are going to a school and starting in a school which is rated as amongst the 100 top schools globally. That's saying a lot. I'm not talking of India. 100 top law schools globally. And I think it's quite remarkable that you are anywhere in one of those. Jindal is rightly called global in its acronym, JGU. And I think it is having this remarkable ranking in the first 100 globally. It is also global because it is truly Vasudhaiva Kutumbakam, a global village with 470 very diverse faculty. Diversity, including a profile of 25 countries in the faculty, is truly a remarkable achievement. And I think to have such an international collaboration of the kind which this university does in terms of opportunities for its students, but above all, it requires organizational ability and dynamism. And I must say, you have an excellent combination of all those qualities in your Vice Chancellor, who has now made this institution in a very, very short while reach the pinnacle. Which now brings me to the opening facet, namely this phrase about lawyer and advocate. So let's start with an interesting question. Is there a difference between the two? Or is it largely a semantic difference without a distinction, or a distinction without a difference? Or is it a highly overlapping concept? Well, we are talking of advocacy and lawyering both in the title of the theme. You know, there is clearly a difference between a lawyer and an advocate, and there should be, and there is. To be one, to be a good one, is not necessarily to be a good other, and vice versa. To be a good advocate is certainly not necessary to be a good lawyer, and vice versa. Historically, two examples come to my mind. There are many more. The junior settleward, the word junior is important because his father was a very eminent lawyer also. The junior settleward, who was our first Attorney General of India, a very distinguished man, was, according to me, and these are all opinions which vary, a great lawyer. But I would not say necessarily a great top advocate. He was extremely solid with a deep knowledge of law. He could make each point from a preliminary objection of wakalatnama to pleadings, onwards to limitation and res judicata, and then on to the merits. Labor it, be very accurate on the citations, and shunned flamboyance, and also shunned what in those words was not a very fashionable word, advocacy. Now, it's very interesting, during his time, his deputy, who later succeeded him, is the perfect foil and the best example for my theme, C.K. Daftari. Chandu Daftari, who remained his Solicitor General and then succeeded him as Attorney General, was, according to me, an exact opposite. His creed in life was minimum work, maximum output. And he took pride in saying so, while puffing his legendary pipe. But he was able to manage it. It's easy to say he's not able to manage it. He was able to manage it because he had this remarkable art of putting across a point pithily. And that's both an art and a science. It is very much innate, but equally and probably more so acquired. And the examples which you will always hear about Daftari, not about Settleward, are legendary, are many, are multiple. Two of my favorite, which of course are well known, and many of you may have heard it, is the first one when he was arguing a matter under the Gambling Act in the Supreme Court in the late 60s, I think, before Justice Hidayatullah's bench. And with a quizzical smile and a genuine puzzled expression, Hidayatullah asked him, "But tell me, Mr. Daftari, what is gambling?" So Daftari paused in his inimitable style, looked a little bit this angle, that angle, and then said, "My lords, it's a very difficult thing to define. But if your lordship will permit me, what happens in your lordship's court on miscellaneous days is the closest example I can think of." The next answer of the bench was, "Notice, stay." He got what he wanted. He was the chap who famously, in a liquor matter, is supposed to have said, my lords, what is a republic without a pub? It is only a relic. So these are examples, and he was certainly not a person who would be as well versed in the law as Settleward. Possibly he was, not possibly, certainly he was not that solid. Now, a rare exception which proves this rule is a chap who had the combination of this, a rare combination indeed, which made him possibly the greatest lawyer and advocate of this country ever. And that is Nani Palkiwala. He had this superb lawyer's solidity, grasp of the most technical, but also this extraordinary advocacy ability of being able to put across that very, very complex tax clause in the simplest of manners. The basic structure doctrine, which is the most remarkable doctrine, which is India's gift to global jurisprudence. We are the inventors, and there are lots of plagiarists out there who have copied us, will ensure that India can never become even a semi-permanent dictatorship. Now, it's not as if basic structure was not around. Basic structure is something which was known. German theorists had written about it. Kelson's Grundnorm, in a sense, came close to it. And there are direct authors who conceived it, wrote about it. And it is partly the concept which Palkiwala lost in Golaknath, the prior case. But the remarkable thing about him that he fashioned it as an operational reality in Keshwanand. Through not only extraordinary research, because the concept was there in jurisprudence, but through his acute insight and the ability to put things in a simple way. So that translation is a bridge between good lawyer and a good advocate. And it is certainly possible to be not the best of both, but a very good combination of both. So this is one interesting and important facet for a commencement class of lawyers to be. A second is, why law? Well, there are excellent small niches nowadays in the world. Many options and sub-options which we never had or never dreamt with, both within law and in other subjects. And there is no clear answer why law, but let me give you an amazing insight which I have gained over the decades. When I joined law, there were three facets, if I was asked to pinpoint, which have radically changed today. Of course, there are many more. Many things have changed. After all, I was entering law 40 years ago plus. So India has changed, the world has changed, and law has to change. But if you were to pinpoint in a minute manner the three main things about the legal profession which have changed, and they also illustrate why you should consider law, not that you should be forced into it, is first and foremost, in my times, as a lot of people of my generation and older, and I'm not that old, will bear it out, law was and remained the refuge of last resort. Point number one. You tried everything, possibly didn't succeed in the civil services, possibly failed in your father's business, possibly made an uncle bankrupt. And then you said, okay, let's try law now. Law to ho hi jayega, law mein kya rakha hai? It almost came along as a taken for granted item. That from being a refuge of last resort to have become an option of first choice, for actually paying handsome sums to people like Mr. Rajkumar for such excellent universities, people do not think of that in the old days for law. So this is the first major reason. And if everybody is saying it's an option of first choice, everybody can't be wrong. Then the second is that people had a very strong law background who joined law in those days. That doesn't mean that you were directly connected, but you had somewhere a grandfather, an uncle, a heavy joint family influence, some historical connection in the majority of cases. Of course, there were a large number of exceptions, but there was this tendency. So the second thing which has changed is you will now be astonished to find people completely unconnected with law generations 7 on your father's side, 5 on your mother's side, as the succession law tells us, with nothing to do with law. Absolutely nothing. And I'm amazed when I get requests for internships and juniorships from architects' children, doctors' children, engineers' children, and above all, a leading industrialist, not merely an industrialist, came to my house some years ago and said, what do I do with this chap? He's not prepared to take up my business. He's thinking of law. I will not name him. But I said, this is terrible for you, but I'm extremely joyous, and I'll mention this in the next lecture I give, that he's even thinking of law. Forget him doing or not, because ultimately parents will not want his business. But he was at a stage where he was on the threshold, and he did ultimately do the law degree, and now he's still not joined his father's profession, he's dabbling in law. So I think this is something which is not there in those days. Architects, doctors. Third is borne out by what the professor said in the opening. In those days, there were very few women in quantity terms and very few of them in operational terms or doing even moderately well. It's as simple as that, put it bluntly. Today, except the very, very top, and there is a generational time which takes to reach that very, very top. And I don't mean the top, the very, very top. Barring that, at every level, women in the legal profession, I'm not talking about law students, which is what was mentioned at the entry level, but they ultimately become lawyers. Women at each and every level are doing extraordinarily well. From the bottom of the rung to below the middle, to the middle, above the middle, and at the near the top. So I think this is again are 3 remarkable changes from the days when I, of course, apart from there are many more that you didn't have sports law and entertainment law. You didn't have these special subjects which you have nowadays. Nobody talks of IPR nowadays. People say, I'm doing patent law. I said, humne to sirf IPR suna tha us zamane mein. Somebody says, I'm doing only copyright law. So these are differences, of course, but they are the 3 most important differences. Of course, all the jibes you hear about law and the legal profession, and they are very humorous and they are very multifarious and diverse. And you each must be having 2 or 3 favorite lawyer jokes. They should not deter you in a literal sense, because they always, according to me, in fact, reflect concealed admiration. As you know, the old days, they used to say, the legal profession is one where you have to first get on, then get honor, and then get honest, in that order. You've heard of the fact that lawyers are the only tribe who supposedly draft 10,000 to 20,000 word documents and call it a brief. Lord Brougham of the House of Lords summed up the sentiment against lawyers in Shakespearean terms, where he said that I define a lawyer as a learned gentleman who rescues his client's estate to keep it for himself, and so on and so forth. But when you have this, you can rest assured that these are only invented for a fairly successful class of people. And that's why I said there is a strong component there of concealed elements, concealed admiration. Well, lest you think that I'm going to beat about the bush even more about art of advocacy, let me turn to the essential elements of the art of advocacy. Now, advocacy, as you remember, I made a distinction between lawyering and advocacy. So we are now focusing on advocacy. Loosely defined advocacy obviously has almost all to do with the ability, the means and the ability to communicate by speech and do it effectively. That is the obvious heart of advocacy. It, of course, encompasses a lot of other elements. It involves putting across a point in a pithy, succinct, relevant, neat, and in a generally methodical and overall pleasing manner. These are not adjectives, huh? These are things which each of them helps. And not everyone in every sentence is able to achieve it. The French philosopher Montesquieu, in one of his essays, put it very well. Montesquieu is the chap who did this famous separation of powers business, which is more observed in the breach in most countries, but it has made him world famous for all times. It's a philosopher who elaborated the doctrine of. So Montesquieu said, every man may speak truly, but to speak methodically, prudently, and fully is a talent few have. And those who are interested in this subject must start on this path of the art of advocacy. Which brings me to the other two key concepts of advocacy, both time and language. Now, obviously, when you have these nice witticisms that brevity is the soul of wit, and how important it is to be precise and brief, you know that they are all intended to be observed only in the breach. But when you breach brevity, you breach advocacy's basic instinct and basic core. You know, it is very, very difficult to be brief. And my favorite quote, which I've said many times, is Dr. Johnson's letter to Boswell, which starts with these words: "Dear Boswell, I'm extremely sorry to have to write to you this long letter because I do not have the time to write a short one." You know, it takes much longer to compose your thoughts and put it across. And so right Dr. Johnson was. So I think along with this it's only the awareness of brevity which is important. But brevity doesn't mean you lose out the important point. Brevity means a certain organization in the mind and preparation. Along with that goes precision. And in fact, it happens largely automatically because one goes with the other goes with the one. It is not difficult and easy to filibuster. And filibustering, of course, is a specific art in certain situations. But filibustering as a habit, you can do it when you want to delay a bill or obstruct a parliamentary proceeding. But to start doing it as part of your advocacy would be disastrous. So beware. The fact that brevity is frequently observed in the breach is illustrated by the English judge who, after 2 days of arguments, could not tolerate the remark of the lawyer who said, "I must apologize, Balance, for having encroached so long upon your lordship's time," kind of suggesting that he's winding up. At which time the judge could not contain himself and burst out, said, "Did you say time, Mr. Counsel? Don't have any worries. You're not encroaching upon time anymore. For a long time, you've been encroaching upon eternity." So this is how you can irritate a judge, you can lose the focus, and you can, of course, lose the case. Because, and especially imagine this is true in the old English time when time was endless, and Indian time when time was endless, not when you have close to 4 crore cases. This is a horrifying figure. As my class at Jindal Law School, when I spoke, we didn't have the post-COVID statistics. It was just over 3 crores. Post-COVID, it is 3.75 crores. If you start having the luxury of eternity in your arguments and advocacy, then you can imagine how rightly a judge would be disgusted. The fourth aspect is language, of course, because the vehicle of your advocacy has to be a language. Now you can take it that by the time my generation is over, other languages will be very much in vogue. And it is very good to have pride in what might be called an all-India language. I won't call it a national language or official language because there is no such thing in the Indian Constitution, but regional languages and Hindi have grown immeasurably in importance. But the good, bad, or indifferent is that the greatest bastion of the English language in this country is, guess what? The judiciary. That is the last remaining bastion, which will possibly by the next generation of students fall. But at least at the moment, you have to live in that ecosystem. And therefore, you have to have a certain mastery of that language, of the Queen's English. The Queen's English can, of course, be very interesting and complicated for those who are trying to be copying it in rote and who have not been colonized. It can have very funny results if you start learning it in countries. But India has an advantage. Our colonization means that our facility with that language is very great, frequently and usually higher than the original owners and inventors of that language. English. However, when, as I said, people who have not the facility in the Indian language start practicing language, there are, as I said, hilarious result. An actual European Council booklet was issued to tell people how not to speak certain manner of English. And in that, they gave many examples, two of which I'll read to you. The Budapest Zoo has a notice outside the zoo, says, quote, "Do not feed animals. If you have some suitable food, give it to the guard on duty." Close inverted commas. Tailor on the Greek island of Rhodes. For Greeks, every language other than Greek is Greek. The tailor in the tourist heavy season put up a notice struggling with his English tourists in the following language. He says, quote, "In such a rush, we will execute customers in strict rotation," unquote. So these are examples of how not to use the English language just because you're speaking English. But yes, all of you should spend a certain amount of focus and time on the vehicle of communication. And it helps if you read things other than law for this vehicle of communication. Law, any case, there'll be enough loaded upon you by your teachers, but read things other than law if you can. The other aspect is, of course, in advocacy, quickness of thought on your feet. Quickness of thought on your feet is willy-nilly a vital part of advocacy, especially now in appellate courts, where even today, to a large extent, the hearing of the case takes place at one go and finishes in one go. Now, in the old days, of course, it was worse because you would have to do the examination in chief, followed by cross immediately on the spot, and then including re-examination. Everything would be over in that 1 hour, 2 hour slot. So there's no question of, but otherwise now in the fact of miscellaneous matters, which are nothing to do with these long matters, quickness of thought, when like a fusillade questions and probing antagonistic, hostile questions are being fired at you, you have to have a certain quickness of thought. Well, don't worry too much. Quickness of thought actually is nothing, is I would say a synonym for very solid preparation. The confidence which solid preparation gives you automatically triggers your mind to give the right answer quickly. Why? Because the recesses of your preparation pull that string which acts as the trigger. But yes, in the what we call the 2020 or T20 world of miscellaneous matters on Mondays and Fridays in Supreme Court, as opposed to the one-dayers, ODIs, and as opposed really to the test matches, quickness of thought is paramount for your notice and stay. And that comes from a solid working familiarity with the pages of the file, but again, not of the file, only of the relevant pages of a file. And you will be astonished that the length of the paper book is usually in inverse proportion to the relevant pages in that paper book, not in direct proportion. So 10,000 word briefs actually end up with just 5 pages which are relevant, and that too a few lines in each page. And it is your job not to start hunting for that needle in the haystack, fumbling before the judge, but to have already pre-searched it and be pre-aware of that hostile question. In all this, of course, something which is underestimated is the power of the rejoinder, which is why, as I said, nowadays in appellate courts, even rejoinders take place in the same time. And more cases are lost or won by rejoinders than people realize. And at that point, you should have had ready your pointed one-line answers to the pointed questions the judge asks, or which have already been made by your opponent, because the rejoinder is the last word. The very purpose of giving a rejoinder, technically under our civil procedure code, rejoinder is not a matter of right, but it is given only to make sure that it's a re-rebuttal of what has been argued. The issue has been narrowed down to the pinnacle of the pyramid. And if you fail to satisfy that pointed query, then you have, in fact, lost the case. The reason why all this happens in a jiffy, in a few seconds, and can happen without you being alarmed, along with the other facet that your ability to assimilate facts, to actually find the needle in a haystack of irrelevant facts. I already made the point. Your ability to assimilate is vital for good lawyering and good advocacy. Especially as you grow in the profession, you will find files flung at you, if you are lucky, as far as government briefs are concerned, the previous night, late in the night. And you are alarmed at the size of the file. But as I said, you will find that the needle is only 3 to 5 pages of relevant lines. And for this, all this, you need to be able to assimilate that, and speed reading in that sense is ultimately a self-preservatory exercise. So if you hone these skills as students, you will all find them of use when you get out of law school, out of Jindal. Memory helps. Some of us curse others who are blessed with a prodigious memory. Their task is made easier. But at the end of the day, you are becoming an expert only for that moment in that case. You should equally learn how to decongest your mind after the case. And that institutional long memory is not required for the details of the case you finished. Actually, what is required are the 5 basic principles you picked up in that case. And normally, as I always say, never be alarmed by the fact that there is such a vast ocean of law. More important than knowing the law is knowing where to find it. Not as quacks wrongly put it, knowing the law is not important, knowing the judge is important. That's not the point. Knowing where to find the law is important. And knowing how to find the law is important, not to know every part of the law. And as you know how to do that, to retain only the 10 basic principles out of the 10,000 you have found in the ocean of law. And you will get that as you keep on thinking of these principles when you apply it to a problem. Each of these principles, as you apply it to every problem which you come, you will find that you are thinking like that. But above all, there is no single quality which anybody can pinpoint. But if you are forced to pinpoint, what is that single quality? Well, above all, like it or not, it is hard work. As everybody says, there are substitutes for Harvard, but not for hard work. 99% is always perspiration. Less than 10%, less than 1%, I'm sorry, is inspiration. That too, if you're lucky. Joseph Story's full quotation is not always cited. Only a part is cited. Joseph Story was a very famous jurisprudential scholar. The full quotation runs like this, quote, "I will not say that law will admit no rival, but I will say that law is a very jealous mistress and requires long and constant courtship. It is not to be won by flinging flavors, as you might win mistresses, but by lavish homage," unquote. So there has to be homage first, has to be lavish. And that is nothing but hard work, which brings with it everything: confidence, quickness of thought, the ability to pinpoint the issue, and above all, the confidence to be able to stand up to a hostile court. The other part, these are all elements of advocacy. These are all qualities of advocacy. These are all facets of advocacy. They may sound very wide and somewhat unconnected, but let me assure you, they go as the fundamental building blocks, the elemental building blocks of your character and persona, both as a lawyer, but more particular as an advocate. Above all of this also is your overall reputation, which you have to build up brick by brick. Law is a dangerous game. You're dealing with dangerous and dirty things all the time. You're obviously having multiple things happening. And therefore, all that it means is a general reputation of fairness, balance, and accuracy. It's very easy to mislead a judge the first time. It's very easy to mislead judges, 5 judges 5 times. But you can be rest assured that your professional progress has come to a stop if your reputation of this kind precedes you. Because it doesn't even help in the short term, but in the medium term, you are dead. You don't live to see the long term. I think if the lawyer has a reputation that whatever the case, he will put the best part of that case in an accurate manner. And that is why life helps you, because life is largely gray. It is not black, it is not white. God has made large chunks gray, and therefore your ability to exploit the grayness to your advantage is what lawyering is about. And when you do that exploitation of gray areas to the hilt, you have to be fair, accurate, and not false. You will soon find, be astonished that judges don't turn the pages to check what you are saying, because they know that irrespective of anything, he will take the liberty to the maximum limit of gray, but he will not call black white, and he will not call white black. And judges will therefore not cross-check your point. That is the whole sense of fairness. Do not climb onto your opponent when he's completely decimated and with gleeful adjectives do the coup de grace. It doesn't help. You're all gladiators and colleagues in a profession. And in the long run, to be very strong, not to tolerate bullying, but to be fair and balanced, makes your reputation before judges, because we are talking of advocacy more than chamber lawyering, but applies to every part of the vocation, as also your colleagues, the community, which is called the legal profession. A word about the word profession, just like I used the word about lawyer and advocacy or advocate. Well, why do you call something a profession and why do you call other things a business? Now, this might sound very arcane, somewhat over idealistic, unreal, but to a commencement class, it must be said. A legal profession is, for that matter, anything called a profession is, and will remain distinct and must remain distinct from business. There are violations, breaches, distortions, but the day this fundamental distinction, watershed distinction is obliterated, will be the end, at least of the profession, not of the business. What is this distinction? The best I can do is to summarize that great jurist from Harvard, Dean Roscoe Pound. He wrote a treatise on the elements, the key elements of a profession which differentiate it from business. And let us stick to the legal profession, because there are the architecture profession and the engineering profession and so many more. But let us look at the legal profession. He said, historically, there are three ideas involved in a profession, and how right he was. And if you remember these three ideas, they are the three distinctions which put you in a separate category from other forms of activity like business. The first, he said, is the idea of organization. That is why you find a large number of those which are called vocations or professions emerge out of a guild, what the old Indians used to call the Gurukul. So you work around a master, around a community. So a legal profession is a community of professionals. Actually, directly the Inns of Court in England arose out of these professionals working around a small group of people together collectively in a place which became an Inn of Court, and is now, of course, Lincoln's, Middle Temple or Inner Temple and blah, blah. So the idea of organization around a concept as a collectivity is what differentiates the medical profession, the legal profession, the architecture profession. They're all guild-based professions from business. You don't need to have that for a business. Anybody, anywhere can do that without this concept of an organization. So an organization is the core element of a profession. Second, the concept of learning. Not that they are any less smart than you. Frequently, they are smarter than you. But a businessman needs no learning. He needs no degree. He does not have to. He may choose to, but he doesn't have to take a law degree from Jindal. A medical doctor has to spend 7 long years minimum, and in most countries, many countries, 10 years to become a doctor, just to become. Successful or not successful, failure or be damned. But first he has to become. A businessman has no entry point issue, that is where learning comes in. It's a noble profession because it is supposedly based on learning. So you take your law degree for granted, you take them as just principles. No, that's what is distinguishing you, whether it's a doctor, whether it's an architect, or it's a lawyer. Nothing of the sort in business. Business requires a different kind of skill, risk-taking, enterprise, capital. Third, he said above all these two is an element of public service. Now this is where the unreal part comes in. But you will be surprised, the business, the professional meaning of a profession must have a supra added impregnation of the concept of public service. The old professionals of the Inns of Court were designated as senior counsel, and the small pouch was put behind the senior gown, not for nothing. The pouch was for a concept that they would be ultimately paid, but paid to do service, not do service to be paid. A doctor takes a Hippocratic oath, which binds him to an organization after learning. Because at the end of the day, of course, he has to charge money, and they will charge, and there are hospitals who refuse you admission without money. But the idea is that he has to ultimately keep his larger obligation to society in mind, which is why lawyers are imbued with hundreds of conflict rules, which is why doctors have the Hippocratic oath, which is why architects have separate sets of ethic rules. I mean, in ethics is very good rules. Everybody has it, but a businessman not normally required to have an ethics rule book. Because this is the element of public service without which you are forgetting the supra-added element, which makes you a profession as opposed to business. Somebody wrote a nice piece about what are the lamps of advocacy. And he identified 7 lamps, some of which are overlapping. I've already dealt with them in a sense of using different words, but they are overlapping. But let me put before you the 7 lamps of advocacy. Of course, the first one is honesty. It might sound like an oxymoron, but you'll be surprised how important it is in the legal profession. It makes for your reputation. It makes for you how judges see you, how colleagues see you, how clients see you. And as I said, avoidance doesn't even succeed in the short run. This first one of the 7 lamps of advocacy make you dependable and reliable, which are 2 qualities which go along with uprightness, integrity, and honesty. The second lamp of advocacy is courage. Again, not necessarily required in every activity. I would say very few, even in the professions, require this. There cannot be a good advocate, or for that matter, a good lawyer, without a very, very hefty amount of courage. And I'm not talking of Dutch courage. His courage has to be 3 words identical: boldness, boldness, and boldness. It is his duty to put across points of view fearlessly, without regard to ulterior motives, and the courage and confidence to speak fearlessly does involve maybe consequences upon himself, but that is the price he has to pay for acquiring that knowledge and discharging his skill. The third I've already dealt with: industry. There is no, as they say, this is the most highest form of drudgery, and it has been called by Charles Lamb the drudgery of the desks. Unfortunately, 99% has to be perspiration. Less than 1%, if you're lucky, will be inspiration. So don't think that these things or the so-called success in advocacy comes easy. Fourth is wit. We've already discussed that. The Chandu Daftari wit. The Nani Palkiwala pithiness, succinctness, which automatically generates wit. The Boswell brevity, which also generates wit. Wit is of different forms, but it has all these qualities of succinctness, precision, pointedness, and of course, humor. Especially in the heat of arguments, you'll be surprised how much tension is being generated. And don't think that you are the one who's generating tension. Judges generate more tension, but the worst is everybody is in tension. for no particular fault of yours or the judges. The nature of the matter is a matter of tension. The client is in tension. The opposite side is in tension, howsoever confident he may look. At that time, it is important to lighten the atmosphere, and the best judges and the best lawyers are those who effortlessly do it without giving anything away. The fifth is eloquence, which we have dealt with in terms of the communication vehicles, language, precision, the art, as Montesquieu said, of communicating pithily and properly. The sixth is judgment. A judgment is interesting, sixth quality, a lamp of advocacy for an advocate. You might think it only attaches to a judge. No. It is the capacity, the inspiration which enables a person to translate good sense into good action. In the case of advocacy, it means translate a good point into an effective argument. The judgment brings with it the necessity to have discrimination. You will be told 28 points with every client. If a lawyer is briefing you, he will make it 13 points. You'll be astonished that you're going to win the case or lose the case only on 3 points. Maybe less. The judgment to be able to identify it, but more than that, to be able to translate it. And translating it is in the same language, but it is still a translation because you give a different facet to the same point. It is exactly like saying that the glass is half empty or half full, but you'll be astonished how much difference it makes whether you're able to convince him it's half full as opposed to whether it's half empty. That is judgment. And the last is the lamp of fellowship, which of course is necessary in the Dean Roscoe Pound concept of organization, guild, a profession. You're not a solo gladiator. A businessman can go with dog eat dog, throat eats throat. He has no community, and therefore he doesn't have to have that extra bit of fellowship. You are in a community, even if you're a chamber lawyer, even if you are an in-house lawyer, even if you are doing not advocacy kind of lawyering. There is a community to which you belong, just like medical doctors belong to a community and architects belong to a community. Of course, some of the negative parts arise also from being a community: incestuous, negative, backbiting, jealous. We're not talking of those. We'll talk about it in some other lecture. Don't forget them ever. They're there. But the point is, fellowship is important, and it conquers a lot of the other negatives I just mentioned. I'm going to end within time, probably a little before 1:15. Let me just wind up by telling you about a few other aspects of contemporary lawyering, because that's also been added as a theme, and I don't want to be accused of missing out a chunk of the theme. Contemporary lawyering, of course, brings in, and lawyering, I mean including advocacy, brings in this whole media issue. Well, 2 points or 3 points about the media. One is, there is inevitably today a compulsion to conform in society, and the compulsion to conform only means this. I always say jokingly, I've told many people that today the biggest form of censorship is not by governments or by Pegasus or by others. The biggest form of censorship is by the compulsion to conform, which means compulsion to conform means that I must say and do what Raj thinks is right, or which Srijat prescribes is wrong, and not according to what I think. So you try to act proper without being correct or truthful. Well, it is good to be that. It is not good to court controversy for the sake of controversy, but as an advocate or a lawyer, you have to have the courage to defend unpopular causes. You have to have the color, because you're talking about the word unpopular. By whose judgment? By an external judgment, not of Miss Shivani, but of the next bystander, Professor Raj. Not of Raj's standard, but by next bystander, Professor Srijat. So it is this compulsion to conform which you have to be ready to defy as a lawyer, not for the sake of sensationalism or over-aggression. And I always told Ram, and I commend him for it, Very few people realize that when Indira Gandhi was killed, there was not one human being on planet Earth who did not blame the three gentlemen of having killed her intentionally. I don't think there's any single human being on planet Earth. It happened in close proximity on 31st of October. All three were sentenced to death by trial court. Two retained death at the High Court, one became life imprisonment. Ram defended them in the High Court, but more particularly in the Supreme Court. And do you know the Supreme Court acquitted one? People don't remember that now. Out of three,
I suppose you're talking about Ram
Jetmalani. I'm sorry, Ram Jetmalani. I'm sorry. So now that is a horrible cause. He was expelled from a political party he was a member of, and I don't agree with many of the things he did. Actually, don't agree. I don't even agree with the content. But you have to remember that you do not judge your client and you do not choose your client. Put that as a placard in your law office. It doesn't mean you are obliged to accept every brief. But if you start judging your client and then choosing your client, then I don't think you have the courage to be a lawyer. And let me tell you, large slices of the public today don't realize this basic point. They will criticize you, they will vilify you, because they don't even understand this. But you have to do that, Tagore, Ekla Chalo. Then you also have to go to the media as a lawyer. I am the worst. I do media as a profession. I'm supposed to be the senior most national spokesperson of a political party. But I think my worst enemies will not accuse me of not maintaining a Chinese wall between my professional activity and what I do in the media. There will be some people who will criticize me, but I don't think, in fairness and objectivity, I have been very conscious, and therefore I have not allowed transgressions. Why? How? Well, one, for a start, 99.9% in the last 25 years or 20 years, I have never had press conferences on a matter which I've just argued. So I go and argue before him, and I go out and do a press conference before him. No. The 1.01% exception would be a case like COVID, where it's a general PIL, where you speak generally. But there also it's a very wrong example, because it's not arguing about the case you just argued. That insulates. You have to be, again, it's not a question of this example. You will have different challenges facing you, not the ones I had. But you have to be aware of these principles. Awareness will make the difference. And the other one is that, yes, speak vehemently in the public domain, even have a press conference. But then that is post-judgment. Post-judgment, there's no problem criticizing. Criticize strongly, don't criticize personally. Ironically, today I am taking a press conference on the wrong OBC judgment of the Supreme Court, which was bungled up in Parliament in terms of passing a wrong law. That judgment has come. The judges invite you to criticize it. But doesn't mean that I go and start attributing motives to judges. All this, ultimately underlying all this, is you have to be conscious that you are not seeking sensationalism. There are lots of temptations of sensationalism. And on the spur of the moment, you'd love to go into that program. But I think your overall longer term reputation as a lawyer and an advocate will suffer. I think there are enough avenues to be very critical without being personal. There are enough avenues to be critical on principle. Conflicts of interest is the last point. I'm ending in about 5 minutes. You have a very difficult task, as every lawyer does. Technically, this poor lawyer is supposed to do the impossible, because he has one duty to the client. He has another duty to the bar council. He has a third duty to the court. And he has, of course, an overall duty to himself. Now, how the poor fellow is going to counterbalance these multiple minimum 4 duties is a challenge. But you have to do it. And many times these are conflicting. Your duty to your client will conflict with your obligation to the court. Well, you have to be aware of it. And you have to not say, oh, what can I do? I'll choose one out of the 4. No, you're supposed to do all 4. You have to harmonize all 4. And the way out which God gives you is that in an actual case, as in real life, there are large shades of gray. You'll be astonished how much you can exploit the case to the hilt for your client, doing your duty to the client by exploiting the gray. But your duty to the client doesn't mean that you go into the black. that this is his signature, but you say, no, it's not his signature, sir. You have to be able to harmonize. And then when you're doing both of them, you will also do a duty to the court by being fair to the court and not misleading it. And let me tell you, it is possible. Not only is it possible, it is highly desirable. It must be something which you start with as an advocate and a lawyer. And all of this happens with a simple thing, simply being aware. To be aware is half the battle won, because you will then consciously act like that. Your training and your ability will make you by practice become like that, instead of stubbornly and mulishly insisting just to win your client's confidence or a third party's confidence that black is white or vice versa. That is an option which doesn't even work in the short term, as I said. Medium term, no question. Long term, no question. Extremely untenable stands deliberately taken for sensationalism, deliberate conscious sensationalism. Let me tell you, that's happening. Don't stand you for long in good stead. It gets you that momentary place in the sun, your glory. That glory is less than momentary. You have to be and sound reasonable. Nobody knows it better than a spokesperson. There are very unreasonable things which one has to defend. You may not agree with it. But there is a way of defending something with a reasonable degree of candor and honesty and sincerity. And that is what a good advocate has to do in his profession, as much as in other walks of life involving the media, for example. Well, enough sermonizing, enough preaching, enough lecturing. Let me end by a small little bit of additional sermonizing, but reminding you that ultimately all of this doesn't matter till it's lab in the world. The greatest laboratory of world is the life and the experience of life. And you are all on the threshold of that second phase of your career after your youth. That is an education which you cannot rival. You are educated, as someone said, your certification is in your degree. You are absolutely right to think of it as a ticket to a good life, but always also concurrently think of it, if not as an alternative, think of it also as a ticket to change the world for the better. I think that dual concurrent awareness is important. Remember always that instruction may end in the schoolroom and the classroom, but education ends only when life ends. And they are two different things. The highest interest you will ever get in life is in your investment in education or knowledge, not merely in degrees. And last but most appropriate for the current world, for the contemporary world, for contemporary lawyering and advocacy, we all live in an age of instant messaging, as Tory Burch put it. And they cannot get more instant than we are. Instant messaging, instant gratification. And that includes Instagram. But there is no way to short circuit the path to success. There is no instant magic button for that. Thank you very much.
Thank you very much, Dr. Singhvi, for an amazingly inspiring tour de force on the evolution and of the legal profession, what it means to be a lawyer today, the art of lawyering, and indeed, what are the lessons learned from your own life, and of course, adding so much of wit and humor and connecting with the young students who are entering into the portals of a university. I'm truly grateful to you that you touched upon so many aspects that not only would resonate with the people who are entering the legal profession, but also many of our current students who are also watching this program. While this lecture was basically intended to celebrate the welcoming of the new students in the 5-year law program, we opened up to all students, and I know for sure that everybody who listened to it immensely benefited by it. There are, of course, several questions that have come in, and I'm conscious that the time is short. So let me quickly jump to the questions, and you can give to the viewers shorter answers. First question is something that I'm going to ask before even I take the question from the students, which is that one of the big dilemmas that young law students face today is to make a choice to enter into the corporate law firm sector or to enter into litigation. I ask this question because of the fact that many young people are even allured to the legal profession for the possibility that they can, they have phenomenal, attractive opportunities, including financial incentives, particularly the corporate law firm sector. So my question to you is that how should they go about making a decision in the next 5 years as to where they should see their life and what ought to be their possible calling in life?
Well, Raj, there is no formula answer. Point one, be aware of the alternatives and the pluses and minuses of each alternative. Point two, let me give you some of those alternatives. But start never with thinking that one sub-branch is better, the other is inferior, the third is more inferior than the second, and so on. Point number three, remember that people like us had very few options compared to the ones you have today. You today have a distinct and a vastly improved corporate lawyering option, which means in-house lawyering. I'm not talking of in-house lawyering. So company X, gigantic or medium, and you're an in-house lawyer. Second option you have is solicitor's firm. Third option you have, after some experience, your own individual small niche firm. Fourth option you have as a junior to a direct litigator, a direct practitioner who's a solo. And fifth option you have is a senior advocate's junior. Let me tell you that though they are overlapping, they are all distinct, these five options. I don't think we had such clearly defined five options at all. Point number four, large number of them are equally valid. Unless you start with that premise, you'll be confused and you will constantly keep having value judgments. And let me tell you that there is an increasing number of people who apply to people like me after having spent years and decades in the other two or three segments, and they want to go into pure litigation. And let me also add that many of them are women. And when I ask them, they say the excitement of it is much more than where we are. So these are all personal. So the fifth point is follow your heart, follow your gut, as I said in the beginning. And let the darts be thrown by you. And once you find that most of the darts are landing on this box, then you are correct. Whichever of the five boxes it is. Sixth point, that today the terms of remuneration in corporate lawyering and in-house lawyering is vastly improved. The in-house lawyer is much more important. In my days, it was the American in-house lawyer without which the company could not move. The CMD was stuck because the law in charge of that firm was saying no. India, it was the opposite. He was a rubber stamp. Today, no more. The law head of a big company has a lot more clout, and even the CMD cannot overrule him easily if he puts up a red flag on law. And lastly, there is great flamboyance. I mean, the gladiators will remain the top counsel, if you want to use the word gladiator. But there's very little space up there. In the second rung also there are gladiators, but there also space is limited. The earnings of a person who goes into the pure litigation will be normally higher after the 10th year than his counterpart in the other four areas. That's a call you have to take. You have to be aware of it. And you've gone from 10 to 20, it should be normally much higher than what your classmate. So, but then your life may be much worse. The calls you have to take. But be aware of them, follow your heart, and you'll not make a mistake. And you also have the option of changing after trying for some time each, because that also gives you an idea.
Thank you very much. I mean, there could be no better answer than how you answered, because this is the dilemma that many students face, and you've said it beautifully. The second question I have for you is that, what are the important things that a student should do in the early stages of one's learning? Because you mentioned, and in your lecture itself, you talked about having a wide range of reading that transcends beyond the law. Now, the 5-year students are uniquely positioned. They are entering into a law school, but they do have, in the first couple of years, they have opportunity to study other subjects. And then in a multidisciplinary university like us, they have many more subjects. But then there's a bias in favor of somehow law subjects are quote unquote more important than the other. So I would like you to briefly reflect on the importance of humanities and social sciences for the law student.
See, let me be clear. I don't know who said it, and not to insult any profession, but as they said, if you know the law alone, you may be rightly called a mason. To be an architect, you have to know many more things than the law alone. Now, that encapsulates a lot of thought. First and foremost, reading doesn't mean what Raj's institution teaches you in school. Reading also means what you do on your own without the Jindal Law School even knowing about it. And today your avenues are very, very large. Number two, if you want to audit courses in your very beginning level undergrad, then normally very good sisters of law historically have been found to be mathematics, strangely enough, history, and literature or languages. These have been historically, and in fact, in that order. You'll be astonished because a lot of law has to do with logic, which is a part of a taught subject of philosophy. I may add, in fact, philosophy. And a lot of that has to do with that logical thought process in mathematics also. But anyway, if you are asking me to be specific, these are the three things which will stand you in good stead. But I'm more interested in the fact that if you read, even if you are not auditing that subject, on two areas of your interest, it doesn't matter what. You take it from me in writing that if it is about arcane, idiotic subjects to very relevant contemporary subjects, just two things which you are well read in, but in a more consistent, organized manner, it will help you in unknown fashions when you have joined the profession. And that, I think, is the thing people miss out. They think that if you are reading A and B, you're taking away from your time in reading hardcore IPR or hardcore contract law, and therefore you will suffer. No. It springs back, it comes in unknown ways and manners later on. But the American style is to audit the widest number of courses in your first and second year, narrow it down but always take things other than law alone. This concept that you jump into law in the first year of 5-year law course is not at all what Jindal teaches you or other people teach you.
Thank you very much. That's fascinating, and that's the right thing that we expect our students to do as well. The next question is about the changes in the legal profession that has happened even in your own lifetime, how you remained one of the most influential and impactful lawyer for over 2 decades. And this question is coming from students who are conscious of the fact that they are themselves going to see much more faster changes in the legal profession, not only from the standpoint of use of technology, but also the nature of law itself. How have you responded in your own life, and what is your advice to young students?
See, it's very presumptuous of me to answer this question. It has to be asked of others. I certainly don't pretend to be either deserving of or capable of answering such a nice, deliciously laudatory question. But all I can say is that to think of myself constantly as a learner brings not only a tremendous amount of information, knowledge, and learning, but also humility. I don't mean humility in show, in talking, but I'm saying humility within oneself that you are open to absorb. Number two, I mean, I could never imagine that I could do 7, 8 cases, and that too alone in the holidays without a junior or a assistant on a platform, all by my little self. I'm not very old, but I'm not that young as most of the people here. And to be able to think that you can manage technology, that too alone without assistance, I'm talking of June, when there are vacation period, with not a single staff or a single junior, it amazed me. It felt like I have gone back to Jindal as a student to learn something all over again. And it exhilarated me after a month of having been able to do it. Now, this is something which Thirdly, I think getting the trust of the community, be it of lawyers or of judges, the same point which I said, your reputation, in terms of that. And fourth, above all of this is hard work. But now to suggest that, everybody has a different element, I think the best to say is good luck. It just happened. It was just good luck. It doesn't mean that there's anything. There are lots and lots of bright people out there. So good amount of luck and synergy happens and matters.
Thank you very much, Dr. Singhvi. We are, of course, unconscious of time, so we'll take a couple of questions only, and then we will move into the next, the vote of thanks. This question is about the choices that the students might end up having, although it's a bit early in their own life, but our students are very conscious of their future also. They are asking that since you went abroad for your higher studies, how much the education that you received abroad has also contributed to the shaping of your own legal profession? In a way, unlike many who have gone abroad and chosen academia, you're somebody who ended up actually coming into legal profession. So what motivated you that, and how that has benefited you to achieve this pinnacle of your own profession?
Well, this is more on a personal note. First and foremost, this is an apt question because it was the worst case in my case, because I did my entire law abroad. So this question, I assume, maybe wrongly, but I think I'm right, emanates from a basic fear that you don't know enough of the law. Or if you go abroad, you will know even lesser of the law, because you're going to be practicing in India ultimately. In my case, in those days, it was allowed and recognized. And even today, it is recognized for just that university. And admission into Cambridge was very cherished. And I did my law from there. So technically, I did not really train in Indian law. And I was terrified. I am now confessing, genuinely terrified. Of course, I reassured myself by Jeremy Bentham's phrase that lawyers are the only persons in whom ignorance of the law is not punished. But that apart, you soon realize that it is much more important to be able to learn law. That's why it's called a profession. Law is not learned merely by the text or by the book. And let me reassure the persons who have asked this question that when you are in practice, you will very quickly get over this fear of not knowing the law, because it is the individual case which will teach you that individual statute. Today, you study the CPC fully. Let me assure you, when the first case of CPC comes, you'll not be able to answer it. Though you studied CPC as a full course, or that matter, the Contract Act. Because how it operates in law, in reality, is the difference between a profession and a class. Secondly, you need to learn case to case. And quite frankly, in any area of law, if you do 5 cases and see the overall schematic picture of that subject, you know enough about that subject. You don't need to do more than 7 to 5 cases of contract law to be able to be a master of that subject. You can study contract law for 3 years. You will not know all the sections the way you're studying it, because that's not the way it works. So I think the technique is what comes after you join the profession. You must have an open mind. Thirdly, as far as coming back is concerned, so don't come back with this terror of not knowing the law. I've had a worse terror. But the second thing about coming back, it all depends on choices. I mean, I was in a place which is a fairy tale town. I always say that if you stay a little longer in Cambridge, and I spent all of 7 years as an undergrad, then as a PhD and all that. I even taught there for 6 months. It's so fairy tale that if you stay there a little longer, you will feel like the whole world is like that. So you have to get out of that fairy tale cocoon. Maybe because of family reasons, the fact that I am very rooted in India, I'm basically, in every which way, a very rooted Indian. And I felt that, at the end of the day, but had I stayed a little longer, I can assure you I would have stayed on there, because I had got a teaching kind of a thing. So you have to, that is when you have to bite the bullet. And that biting of the bullet happens, today it will happen much more in favor of coming back to India, by the way, because in English QCs desperately want to practice in India. The Indian legal market is booming. It was not there in my time. So therefore, one is that. B, the fact that you have an ecosystem here, which you are more familiar, with which you like, which you are thriving. And C, ultimately a personal predilection. Some people don't like the chick of India. Rightly so. And if you are really, then of course, it's an equally good thing to be teaching something somewhere or doing some other kind of a, commercial job in a law firm abroad. There are no major value judgments. Today, the world is a global village. And if you're doing something in, a top firm in New York, rest assured that you're going to be interacting with India sooner than later in many ways you don't understand also today.
Got you. Well, we are coming to the end of the program. I am going to ask one last question to Dr. Singhvi. This is a question that I have personally struggled with as a law professor, as a law teacher. The challenge of building and establishing a rule of law society in India is writ large. All of us who are engaged with the law are mindful of the fact that law and system of rule of law is essential for strengthening our democratic institutions. But at the same time, we are also living in a society where the very idea of rule of law is constantly threatened, undermined, violated, and occasionally even done with impunity. So how do we instill the faith of the rule of law among young people in an environment where law is unfortunately not taken seriously?
Well, you have me there, Raj. Not only is it a very important, but also very complex question. And quite frankly, it can be the subject matter of a one full seminar of 3 months course. But so there's no easy answer, no quick answer. But I think to embed rule of law in the psyche of a society is the focus and should be constantly reminded to that society. One way is ultimately for that society to realize that rule of law pays. See, let's be very clear. We are all selfish. God made human beings to be selfish. That's the gene. Ultimately, all the preaching I do will not work unless it is found that it pays to have rule of law, at least in the medium term. Number two, the more you are allowing people to get away with what you think is a direct violation of rule of law, the more cynicism and causticcism and disbelief you are spreading in what you want to counteract, because people will stop having faith in rule of law. So I think punitive action of an exemplary nature to tell people that it doesn't pay not to have rule of law. And I think at the end of the day, it depends on the enforcement. You can have all teaching, all sermonizing, all good principles. And I always say we are an over-legislated, under-enforced country. Where you fail is the enforcement. Because it is that enforcement, either positive or negative, which inspires the confidence in the rule of law. There is no point all of us speaking about it if the next guy in the street knows that it pays to do it by the ADR. The best ADR, as they said, is this ADR of the street, alternative dispute resolution. Now that concept has to go. You have to realize that the ADR cannot be that. And that is only by exemplars, which are manifold and multifold. It is happening, but not enough. And it's a continuing challenge.
Thank you. Well, thank you so much, Shambhavi. You can proceed forward. Yeah.
Thank you, Dr. Singhvi, for that fascinating and truly inspiring commencement lecture, and also answering the inquisitive questions from our students. I am sure all of us, especially the incoming students, have benefited and are truly inspired by this lecture. As the program draws towards the end, I request Professor Sridhar Patnaik, Registrar, OP Jindal Global University, to present the concluding remarks. Over to you, Professor.
Thank you very much, Shambhavi. Good afternoon, everyone. It's indeed a happy occasion to be with you all today. And it's a pleasure and delight to listen to Dr. Abhishek Manu Singhvi. And also, as always, it's a great learning experience listening to him. And we could not have asked for more in terms of the topic chosen to speak that aptly captures the philosophy or the idea of studying law and studying law at the Jindal Global Law School that is admirably steered by Professor C. Rajkumar, the founding dean and vice chancellor, and his team of accomplished faculty members comprising of historians, anthropologists, lawyers, and engineers, all within the Jindal Global Law School. So we are immensely thankful to Dr. Manu Singhvi for taking time out of his hectic schedules to address all of us. I also take this opportunity to welcome all the 5 years law students belonging to the BA LLB, BBA LLB, and the BCom LLB programs at the JGLS. Let me congratulate each one of you on your admission to the law school and to the university. You all are exceptional people and you richly deserve this recognition. Normally, this time of the year, the campus is abuzz with academic and co-curricular activities, with each one of you getting to know your faculty and fellow classmates. But however, unfortunately, due to the pandemic, we could not have a sort of a commencement lecture and the academic session in a physical setting because these are very special circumstances. But this has indeed given an opportunity for even your parents and friends to take part in the activities that we have organized for all the newly admitted students. And at the JGLS, we have an enriching academic and social ecosystem that will help you develop all the essential capacities intellectually, socially, and emotionally. And I can assure you that you will have an inspirational experience being at the law school as you will thrive on the continuum of law and allied disciplines with a rich pedagogical investment pertaining to a coherent approach to the reading of law and understanding the nature of law as observed by both Dr. Abhishek Manu Singhvi and Professor Rajkumar. And such a learning and qualities are indeed important to do well in your lives and career. And friends, I must also tell you, being a university student is a great responsibility towards your learning, a responsibility in order to even respect all the university regulations, spaces, and diversity. But it would indeed be an enchanting experience being at the OP Jindal Global University, which is a place of ideas, bonhomie, and eloquence, and we take the approach of student-centric learning. Therefore, I suggest you to focus on the long-term planning and benefit from the learning opportunities we provide within the classroom and in the realm of university life, and exercise your freedom and responsibility with a sense of discretion and capture the multiple narratives of a university legal education. And as part of which, we have planned number of activities to help you induct into the JGLS. You already completed the pre-semester training and immersion program, and soon you will have a resource orientation program as well. In closing, I wish to sincerely thank our commencement speaker, Dr. Abhishek Manu Singhvi, once again for his erudite address. And also I would like to thank all the colleagues from various offices at the JGU who worked very hard and tirelessly in ensuring a successful inauguration of the academic year and who worked towards putting this wonderful program together. It is a collective effort and a university-wide effort. It is difficult to take all the names, but I would like to sincerely thank the Dean of JGLS and the Executive Dean and his entire team members, supported by the administrative staff members, the Office of the Admissions and Outreach, and in particular, the outstanding leadership of Professor Anand Prakash Mishra and his able colleagues, the Information Technology team and the Communications Office, and of course, the Office of the Registrar and the Office of the Vice Chancellor. I would like to thank all the students and the parents for their active participation and everyone who attended the lecture this afternoon. Our best wishes to everyone on a successful start of the academic year. And being at JGU is a transformation bridge. So please make the most of it during your academic stint at the university. The program has ended. Thank you all very much.
Thank you. Thank you so much.
Thank you, professors, and thank you everyone for joining us today. Have a great day ahead and hope to meet you all in person soon.
Thank you.
Take care. Thank you.